everyone. My name is Troy Tyson. I'm an attorney practicing in the Indianapolis area. And in this video, I want to talk about what you can do if you're a tenant who's being evicted by your landlord. A couple of things before we get started. This is not legal advice. It should not be construed as such. And also, this video does not establish any attorney-client relationship. And one other thing, most of the items that I talk about are based on Indiana law. That's where I practice. So while there are some similarities between Indiana's landlord-tenant laws and some of the laws of other states and other jurisdictions, you definitely want to look into your own statutes if you live in another state outside of Indiana. So to begin with, the eviction process can be an extremely stressful one for tenants. It's very disruptive to a person's life. And whether you've been living in a place for 4 weeks or for 10 or 15 years, being evicted is a very unpleasant process. And a lot of tenants, they don't know the details of landlord-tenant law. And that's understandable because most people don't sit around reading law books all day. So a lot of them are ignorant of the law and they're ignorant of how to proceed accordingly. And landlords very often take advantage of that situation. Most tenants do not know their defenses. They don't know what rights they have. So landlords pretty much roll over them. Many people, when they receive an eviction notice, they go into fright mode and they really believe that there's nothing that they can do. They just kind of roll over and accept the eviction as a completed fact. And the truth is that in most cases, the law, at least in Indiana, it really is heavily favored towards the landlord. And in most cases, tenants are going to lose. In most of the cases that I've seen, I put it as high as 90–95%, assuming that landlords have done their due diligence and that things have been done properly, assuming that they take the case to court and they have all of the paperwork and everything in order. 95% of the time the tenants are going to lose. It's pretty matter of fact. So I don't want to give away the impression that just because, if you've received an eviction notice, you're automatically going to get out of it. It's certainly not that simple. However, I do want to present some things that you might be able to hold up as defenses if you are in the process of being evicted. So the first thing is, don't be afraid. That's the worst reaction that you can have to being evicted, because you'll naturally freeze up, you'll go into paralysis mode, and you won't take effective action. Whether you win or lose at trial for an eviction is almost beside the point if you're not going to take action. So you can at least begin to take some steps to help yourself, even if that means beginning to look for another place because you think the eviction is going to go through. It's always better to immediately snap into action as soon as you get that eviction notice and not crawl up in fear. But in terms of the actual defenses and how you would respond to an eviction notice, the first thing you want to do is check your lease. Okay, a lot of tenants, I would say most tenants, certainly after they sign the lease, initially after moving in, never take time to look through their lease. And that's a big problem because it's possible that the landlord has violated some provision of the lease, or it's possible that, maybe there's something in there that can prevent the eviction. It's not likely, but it's possible. So first of all, check your lease. The second thing is, you want to make sure, and this is the first real defense that you'll have if you go before a court, you want to make sure that the landlord has gone through the eviction process properly, okay? And usually when landlords haven't done this, it comes in one of two ways. First of all, landlords will undertake what's called a self-help eviction, okay? Here in Indiana, and I believe it's the same in most states, you can't just go in and lock a tenant out of their home, okay? You can't just go in and remove all of a tenant's items just because they did something that you felt violated the lease or because they didn't pay the rent. You can't do it that way. That's called self-help eviction, and in Indiana, that's improper. And if a landlord has gone in and locked you out of your home without going through the proper channels and going through the proper process, that is a valid defense for blocking the eviction, okay? The second way that landlords don't properly do the evictions is that they don't file all of the proper paperwork at the right time. And namely, the most important thing that they have to do before they can file an eviction is that they have to provide you what's called a 10-day notice to quit. And that is, they have to provide you with a form that says, I want you out of here and I'm going to evict if you're not fully paid up in 10 days. And if they don't provide that to you, they cannot properly proceed with eviction. Now, courts will not, if you go to court on an eviction, courts will not know automatically whether a landlord has provided a 10-day notice to quit. Okay, and sometimes they won't even ask. It's up to you to raise this defense, and that goes for all the defenses. Courts many times will not ask you, is it proper? Has it been done right? That's up to you to raise those defenses. I would say, in my experience, most courts will assume that the eviction is proper and that the tenant has not done what they're supposed to do, and they'll just proceed accordingly. So make sure that the landlord followed those eviction procedures properly, and that you did receive your 10-day notice to quit, and that the landlord did not pursue self-help remedies. Because if he or she did not, that is a defense that you can raise. The next thing is that you can argue that the rent was paid. The main reason why most tenants are evicted is because they didn't pay rent. I'd say 98% of the time it's because they didn't pay rent. Obviously, if you can prove that you paid the rent, then you can avoid eviction, and you can take that to court, and that would be a valid defense. In most cases, tenants, if a landlord says they haven't paid rent, the tenants haven't paid rent. So that's going to be a small, very small percentage of people who have that defense. However, a somewhat similar defense to that is if you've paid partial rent. I had a case where a landlord pursued an eviction, filed all the paperwork, did everything properly, and then after he had filed the eviction, the very next day, he accepted a check from one of my tenants for about half the rent. Well, that destroyed the eviction, and he had to go back and start all over. So most judges, if they find that a landlord has accepted partial payment of the rent after an eviction, they will see that as the landlord having entered into a new agreement with the tenant. Okay, and the last thing that you can rely on as a defense is actually a federal defense, and this should apply in all states. According to the Federal Fair Housing Act, landlords cannot discriminate against people, against their tenants, based on race, religion, gender, or national origin. So if you believe that you've been discriminated against and you're being evicted because you fall into one of those because of one of those categories, that would certainly be a valid defense to any eviction. Now, one other thing I should raise before I go, that is, just because you beat an eviction based on one of these defenses does not mean that you won't be evicted. Usually what it means, in the small percentage of cases that actually beat evictions, usually what it means is that those landlords just have to go back, retrace their steps, and they're going to refile and do it the proper way. And in almost all cases, if they have to go back and start over, they're almost never going to make the same mistakes that they did the first time. So you should also keep that in mind as well, that even if you're beating an eviction and you come out ahead, you probably are going to come under an eviction at some point in the very near future, as soon as 30 days. So you should also prepare yourself for that. Okay. If you have any questions or you need help with your legal issue, feel free to give us a call at 317-514-2681. That's 317-514-2681. Thank you.